if you're just joining us, good afternoon. You're still watching Newsfeed, the PM edition. Let's continue here. On Thursday, the Ad Hoc Committee on Section 25 sent packing two departments that were meant to make presentation. This was on amending the Constitution to allow for expropriation of land without compensation. This was despite the invitation to the departments, asking them to make presentations on the drafting of the 18th Constitutional Amendment Bill. To unpack the story, I'm joined now by Associate Professor from the Northwest University Law Faculty, that's Almine Duplessis. Prof, good to have you on the program this afternoon. Let's first speak about those two departments that were sent packing this week. What happened there?
Yes, good afternoon. So this round of public hearings, people were invited to make oral submissions on the wording that was published in the end of 2019. And the hearings were supposed to take place last year in February, or March, and it was then postponed due to COVID. And that is where we are at the moment. So people were specifically invited to comment on the wording. And we must remember the mandate of the committee is to make explicit what is implicit in the Constitution. And it seemed from what the advocates said at the hearings, the invitation only said that they must come and give their inputs. But when they started to give inputs on the wording of the 18th Amendment Bill, they were stopped and they were said that this is not their brief. They were supposed to come there and enlighten the committee on the challenges. That is the Department of Public Works that's responsible for the expropriation bill, and the Department of Agriculture, Rural Development and Land Reform. And the committee said they were specifically invited because through this week's oral hearing, it became quite clear that there's quite a lot of problems in land reform, and a lot of people blamed, especially the Agriculture and Rural Development and Land Reform Department. So the committee wanted to hear from them what the challenges was. And it seemed that they miscommunicated, so they were sent back again to come and brief the committee at some other time about the challenges. And that was basically what happened there.
I want to reflect on a statement which was released by the DA. They are raising issue over the exclusion of oral submissions by the Section 25 Ad Hoc Committee. They're saying that it is a violation of the Constitution, and the party also says it will submit a statement of objection to the chairperson of the committee, that of course being Matole Motshekga, on what it terms his unconstitutional ruling denying a request by these organizations which had requested to make oral submissions. What were your observations there?
So, as I said, this 18th Amendment Bill was published already in December 2019. The closing date for the written submission was in February, and according to the schedule back then, the oral hearings at Parliament were supposed to start somewhere in March. You must also remember there are oral hearings in the provinces as well, where the committee actually went out to the provinces to collect oral statements from ordinary people who don't normally, travel to the Parliament to make the submissions. And so a lot of time have passed, and they're done with the provincial oral submissions. And the argument of some of the committee members was that the people who wanted to make oral submissions at Parliament were free to do so in the provincial hearings. We don't need to hear about, of these organizations in Parliament. But the problem is the initial expectation was created that if you did indicate on your submission that you do want to make an oral submission, that you will be invited to Parliament. That's normally what happened, and that therefore you don't need to go to the provincial hearings. And I think that is where a lot of the misunderstanding comes from. There was also a lot of submission received. I'm not sure whether they could really check whether everybody that made a submission and said they want to come and do an oral submission in Parliament could be accommodated because of the number of submissions that was made. The information is not all that clear, but somewhere in between all that, there seems to be, that seems to be the opinion. But I must say, initially, they only wanted to invite 6 organizations to do oral presentations, and they ended up inviting a lot more organizations, including organizations like the Legal Resources Center and other NGOs that do public law litigation, to come and enlighten the committee about what they think should happen.
Prof, I want us to get some context here, and for you to explain to us where the process is right now.
Okay, so I think what also confused a lot of people is this week the comments on the expropriation bill, which is a totally different, process, was also going on. We are now just talking about the amendment for Section 25. According to the program, they are going to look at all the oral submissions and all the written submissions that was received in April, and they're going to deliberate on it in the ad hoc committee, whereafter they are going to ask the legal office at Parliament to come up with draft wording, which they will then deliberate on. And finally, at the end of May, they will come up with the wording, the final wording for the amendment of Section 25 and a report, and submit that to the National Assembly to be voted in or not. We're not sure what will happen then, to amend the Constitution, or if they don't vote it in, to not amend the Constitution. So we are working with a little bit of uncertainty still.
And what's your response to those asking, where's the public participation process at?
So I think we must talk about what public participation entails. So Section 59 of the Constitution requires public participation, but the Doctors for Life case made it clear that public participation is more than just a mere tick box exercise. It's actually inviting people and engaging people, and that democracy is more than just voting for people to sit in Parliament. It's also participatory, and I think it's one of the values in our Constitution as well. We're a participatory democracy, and I think that is very important, because the question we can then ask was there real participation? And that will depend. If people said they want to come and make an oral submission, and there was an expectation created that they could come and make an oral submission, there might be a problem there. I also think what I was quite disappointed in is there's no real engagement with the issues that's brought before the committee. I don't know if they will deliberate on it, when they go back and they reflect on everything that was put in front of them, and then come back and answer people to say, listen, we heard what you said, and this is what we deliberated upon, and this is our answer to you. I thought that was lacking a little bit in the previous process, where the Constitutional Review Committee listened to public participation. It wasn't really engagement with the issues that were brought to them, where people said the problem with land reform is not necessarily with the Constitution, it's with implementation. We lack proper institutions, and there was not really engagement with that. And for me, the way I would like democracy to be, I think that is lacking, but it might be that they have ticked enough boxes to get away with it, if I can put it that bluntly.
I want us to reflect again on the DA statement. They make all sorts of accusations against the chair of this committee meeting, that's Matole Motshekga. They're accusing him of short-circulating parliamentary processes and even denying South Africans their right to be heard on one of the most consequential pieces of legislation since the dawn of democracy. What are the implications of this alleged rush to meet deadlines?
So it's very difficult. I'm coming from a legal perspective. So what's happening here is a political process, and I've learned over the past 3 years that politics, it's messy, it doesn't follow a linear process. So, we are keeping an eye. But one can only actually make a definite statement once the process is finished. And that's also what the UDM case say, that while the process is going on in Parliament, you cannot stop it, you cannot litigate on it. You must wait for that process to finish before you can make an evaluation of whether it was proper or not. And I think that is, I think the DA is trying to warn them to say, listen, we are keeping an eye on that, because they cannot, institute any sort of legal proceedings until the process is finished. So, and it's difficult for me to make an evaluation until this process is finished, because we don't know what's going to happen in the next 2 months. But I know a lot of people are keeping an eye on this to ensure that specifically also, as I said before, the submissions that was made are actually shown to be reflected upon in the committee, and not just, it was not just a tick box exercise to invite people and to come in there in order to push through what they wanted to do from the beginning. So I think that is sort of the complexities that we are dealing with at the moment.
So you touched a bit on the issue of the public participation process. I just want to find out the implications of this apparent failure by the committee to validate public participation in its process.
So if there's not sufficient public participation, it's of course possible for whoever claimed that there is no sufficient public participation to go to court and to challenge it. We've seen that with the Restitution Amendment Bill that was taken to court by the Land Access Movement a few years ago. and where the court said they also looked at what does public participation entail. And once the court might find that there was not sufficient public participation, that bill can be declared unconstitutional because the process wasn't followed. So it can either be unconstitutional, an amendment bill can either be unconstitutional because it's also a little bit more complicated than that, but because it's against the Constitution, but there's also the UDM case that say once it is part of the Constitution, it cannot be unconstitutional, but also because of the processes. And I think the committee would do good to reflect and to ask themselves whether, and to justify if they think that the public participation process was sufficient in terms of Section 59 of the Constitution.
So I guess my next question would be, where to from now? Do we expect more oral submissions to be made by interested parties?
I don't think they will invite other people to come and make oral submissions. What they have indicated is that they will contact the relevant departments that's been implicated or that they want answers from. They will probably make an appointment with the Department of Public Works again. I know there was some anger because people felt that the expropriation bill is running ahead of the amendment of the Constitution, and that the amendment of the Constitution must come first before the expropriation bill. That's under the Public Works Department. So I think they will invite the Public Works Department again to see what the issues are there. The Department of Agriculture, Rural Development and Land Reform will probably also have an opportunity to submit their the problems that they experience as a department in land reform for the committee to also take into account when they think about the possible wording of the amendment of the Constitution.
All right. And how? And how do we? So for those who are interested in making submissions, I mean, is there even a window of opportunity to do so?
No. So the date for written submissions, as I said, closed already last year in February. And then the oral submissions and the provincial oral, when they made the opportunity for people in the provinces to come and have their say, that also closed. So really all what's left now is for the committee to deliberate on all the submissions that they received.
Well, Prof, we do thank you very much for that explanation. That's Associate Professor from the Northwest University, the Law Faculty there. That's Elmine du Plessis.